as well as confront its challenges. As I stated in my address last year, the opening of legal year is a time for reflection, renewal, and dedication to the values of justice, fairness, and the rule of law. It provides an opportunity to acknowledge the work by the judiciary in the last year, while also looking forward to the challenges faced in the period under review, as well as opportunities that lie ahead. The opening of the legal year is consequently more than a ceremonial occasion. It is a moment when we, as officers of the law, pause to reaffirm our dedication to upholding justice, ensuring the rule of law, and protecting the rights and freedoms of all Nigerians. The judiciary is, after all, the bedrock of our democracy, and it is through the work we do here that justice finds expression in the everyday lives of our citizens. Upon assumption of office as Chief Justice of Nigeria, my Lord Honorable Justice Motomo Kuderaki your Lordship made it clear that the court's urgent task was restoring public confidence in the judiciary. Thus, your Lordship has consistently reminded judges of their sacred oath. Addressing newly appointed judges recently, your Lordship ordered them thus: let your judgments be reasoned, impartial, and courageous. The judiciary, as the final arbiter of justice, depends on the credibility of its officers. Each of you now bears a share of that institutional body and of that honor. We know the many structural reforms undertaken by the CJN upon assumption of office. I'll mention a few. The embrace of technology as a tool for transparency and efficiency. The merging of the rules of court. The merging of the court records processing unit into a single unit. Ensuring better case management and drastically reducing cases of missing files. And the creation of central information unit to give lawyers and litigants real-time access to case information. Highly commendable is the scrapping of the paper-based and cumbersome enrollment of new lawyers and replacing it with a digitized process. Thus, details of new wills are now uploaded online, with candidates completing enrollment digitally and receiving their enrollment numbers electronically. Posterity will always praise the new NJC transparency policy, which requires that all judicial appointment memoranda will now be published at the initial stage as part of the comprehensive reforms in the judicial appointment process. Despite these efforts, more work needs to be done about changing the negative perception of the judiciary, which is best captured in the words of His Eminence, the Sultan of Sokoto, Mohammed Saad Abubakar, in his speech at the opening ceremony of the Nigerian Bar Association Annual General Conference in Enugu, when he warned that today justice is increasingly becoming a purchasable commodity, and the poor are becoming victims of this kind of justice, while the rich commit all manner of crime and walk scot-free, he said. The Sultan's speech once more reminds us that perception is greater than reality, and that with reality there is not much room to maneuver. With perception, we can exaggerate or modify according to the need. The Sultan's statement that the rich evade accountability while the integrity of the judicial system is being undermined by corruption and inequality once more reminds us that perception is very important. And as we always say, now public confidence in the judiciary may have plummeted, but we can reverse many of the negative perceptions in this legal year. The computerization of the litigation process, including electronic recording of court proceedings in all superior courts of record, is a measure that must be bettered with utmost urgency. Nigerians, particularly those from rural or marginalized communities, should be able to access the justice system at very little cost. The various rules of court must be amended to provide for e-filing, virtual hearing, and speedy dispensation of cases. My Lord, it's now 26 years since we returned to democratic rule. In those times, our democracy has been tried in various ways. I recall the promptness with which this honorable court resolved the question whether the decision of Atiku Abubakar to run for vice president after winning the governorship election in Adamawa State, entitled INEC to conduct fresh elections or in circumstance allow for the swearing in of his running mate, Boni Haruna, as governor. This court was also ready to resolve the question whether a president could remove a sitting vice president merely because he had decamped from the president's political party. It interests us to note that the case, reported as AG Federation and Abubakar citation supplied, started in the Court of Appeal via an originating summons filed on January 4, 2007, on February 7, 2007. On February 7, the matter was heard and judgment delivered by the Court of Appeal. The Court of Appeal to the Supreme Court was determined on April 20, 2007. The judicial was hailed for coming to the rescue. Indeed, Nigerians and the international community praised the judiciary as the bastion of the rule of law. It was widely celebrated as the last hope of the common man. Nigerians want to see this reflected in all issues confronting our democracy. This court successfully handled over 1,000 pre- and post-election cases within 60 days on filing of the notice of appeal. In his speech by the President of the Federal Republic of Nigeria, President Bola Ahmed Tinubu GCFR, declaring the end of the state of emergency in Rivers State, the President said that there were no less than 40 cases instituted before the various courts, including this court, challenging the declaration of emergency. It is really troubling that only one of the cases was decided before the expiration of the state of emergency. The one initiated before this court does not have a hearing date, even after the expiration of the 6-month period. The last time a state of emergency was declared in Plateau State, it took this court more than 2 years to decide the matter. The judgment is reported as Plateau State and Attorney General of the Federation citation supplied. At the time of the judgment, the people of Plateau State had forgotten that a state of emergency was ever declared. This is in spite of the fact that by the court's record, the case was filed on 24 June 2004, about 36 days after the declaration of the state of emergency in the state. And justice judgment was only rendered on January 2006. What is more disturbing is that the Supreme Court missed the opportunity of spelling out when the President can declare a state of emergency and the extent to which the declaration will affect democratic governance in the affected states. Nigerians really wanted this honorable court to determine whether the President, in the exercise of the powers under Section 305 of the Constitution, can dismantle democratic structures in the state by suspending the governor, deputy governor, and members of the House of Assembly. If, for example, the court subsequently answered this question in the negative, of what benefit will it be to the people if the decision comes after the state of emergency has been lacked by a fraction of time? Delay in deciding such weighty constitutional matters risks sending the wrong signal that the judiciary is indifferent to issues that affect governance at its most fundamental levels. A prompt determination would have clarified the law, reinforced federalism, and ensured that the wheels of government and the grassroots continue to run without hindrance. My humble note, my lords, that both the cases of Adegboyero and AG Federation and Williams and Majek Odumi, number 2, citation supplied, which border on the exercise of powers under the State of Emergency Act of 1962, were decided during the period of the declaration of the state of emergency. As the saying goes, justice delayed is justice denied. Clause 40 of the Magna Carta of 1215 states this principle as follows: to no one will we sell, to no one will we deny or delay justice, or deny the right of justice. Where there is delay in legal process, it harms the victims and undermines their accountability, thereby effectively denying justice. The NBA urges this honorable court with greatest respect to make a mark in history, by ensuring that matters of urgent national importance are not left in limbo. Swift and decisive justice reinforces the court's role as a stabilizing anchor of our democracy. My equally use this opportunity to call on this honorable court to fix a special session for the hearing of appeals to the court against decisions of the Legal Practitioner Disciplinary Committee, as issues of discipline appears not to be receiving the priority attention it deserves, as well as clear the confusion as to whether appeals can lie directly from this court from the decisions of the LPDC. This call has become pertinent in the light of recent decisions by this court declining jurisdiction and referring parties to a non-existent appeals committee of the body of benchers. We thought this matter had been laid to rest by the decision of this honorable court in Obia Jolonwa and NBA, decided in 2019, citation supplied, where this court held by Kuman Bayan Akas JSC retired that any direction given by the disciplinary committee against a legal practitioner invariably is challenged at the Supreme Court, and this is the rationale for excluding the Chief Justice of Nigeria and Justice of the Supreme Court from being members of the disciplinary committee. And the court went on in that case to acknowledge that Mohammed Adoki, as Attorney General of the Federation, had gazetted and incorporated the provisions of the Legal Practitioners Amendment Decree of 1994, which abolished the Appeals Committee of Body of Benchers and gave direct right of appeal to the Supreme Court. My Lord, a look at the recent shortlist of candidates for appointment to the Federal High Court bench shows that majority, and by estimation about 80% of the names are either staff of various judiciaries, most likely registrars, legal advisors, or officials from government agencies. There is a dearth of private legal practitioners in this list as well as many lists that come up for consideration in recent times. This seems to be a pattern which is not limited to the Federal High Court. There seems to be a pattern. It appears to be a new trend that private legal practitioners are now deemed less worthy of appointment to the bench. While we do not suggest that judicial staff, prosecutors, and civil servants are not eligible for appointment, we deprecate a system that seems to give them prominence over private legal practitioners. The majority of appointees should be the practitioners who practice daily before the courts to which appointment is being considered, and therefore would appear to have more requisite experience. This concern has necessitated our call necessitated a repeat of the NBA's call for the amendment of Rule 3.4 of the guidelines and procedural rules for the appointment of judicial officers of all superior courts of record in Nigeria, which empowers the Chief Judge as the Chairman of Judicial Service Commission or Committee concerned to make a provisional shortlist on the merits consisting of not less than twice the number of judicial officers intended to be appointed at a particular time. This rule gives a lot of power to the Chief Judge and Chairman of the JSC and would appear to be used in a manner that may not always be merely trivial. We are of the view that processes that leads to the shortlist of candidates needs to be further reformed and made more transparent. The Chief Judge should not be solely responsible for preparing the shortlist. The general perception is that the appointment of judicial officer is influenced by politics. The mode of appointment should be such that more parties, especially independent parties, should be involved. The mode of appointment of judicial officers is therefore general principle. In the communique issued at the end of the General Conference in Port Harcourt in 2011, the NBA observed there are a lot of legal practitioners in Nigeria who are not only honorable, patriotic, transparent, hardworking, and incorruptible, but also fit and proper for appointment to the bench and elevation to the Gambia, but are bypassed on account of mundane considerations, especially the fact that they should allow those who have labored and suffered on the bench to benefit from such appointments, quote and unquote. After all, it is said that these private legal practitioners have been enjoying themselves. We opine that if it is indeed, it is based on connection as many believe it is. It can only lead to the involvement or interference by non-judicial or legal actors in the process. The involvement of politicians in the appointment will no doubt ultimately lead to interference by these individuals in the judicial process. Such interference will wrongly justified as a payment of favor. Persons selected for judicial office shall be individuals of integrity and ability with appropriate training or qualifications in law. Any method of judicial selection should safeguard against judicial appointments for improper motives. As we have pointed out repeatedly, the poor quality of appointments in the judiciary will be the bane of that judiciary. We therefore propose as follows. Those who apply for appointments as judicial officers referred to the High Courts, Federal High Court, NIC, should be subjected to written tests conducted by an independent board. The results of such an examination should be published within 6 hours of the completion of same. Presently, even though there's a written test, the results are never published. And it is never easy to say whether reliance was placed on the outcome of these results for the shortlist. Such an examination should not only test their knowledge of the law, but equally test their verbal and quantitative aptitude. Thus, that should be structured in a manner that ensures the prospective judicial officers show their legal writing skills, comprehension, and legal reasoning skills. Judicial appointment process should be reformed to focus on skill, professional and technical ability in relation to integrity and personality. Appointments into the bench at whatever level must henceforth be predicated upon merit and concurrent recommendation from the bar. My lords, may we respectfully note that the bail process continues to be a tool of abuse of judicial power, oppression, unjust demands, overcrowding of the detention center, and delay in many courts in Nigeria. This abuse is best highlighted with order made by Chief Magistrate Court last week, Obin and Jemanzi, for the remand of the Owerri Correctional Center of our colleague Chineduago after arraignment on charges alleging cyber stalking, criminal defamation, and incitement. Some judges and magistrates are increasingly becoming enablers of political oppression and suppression of dissenting views by remanding persons charged with alleged criminal defamation or cyber stalking under Section 24 of the Cybercrime Prohibition and Prevention Act 2015. Judges and magistrates increasingly deny bail when such charges of internet or online related offences are preferred against defendants despite the matters being ordinarily bailable. It is then worrisome that even though the law provides that a court may require a suspect or defendant to execute a bond with or without sureties for his appearance before a court, our courts rarely utilize such procedure. Rather, the bail process has been rendered very technical, time-wasting, and cumbersome. Sometimes courts impose bail conditions that amount to denial of bail. At other times, they will impose a condition requiring the prosecutorial agency or some other third party to verify sureties before a defendant could be released on bail. This has led to allegations of extortion, abuse, and prolonged detention even after bail has been granted because of the deliberate delay in verifying such sureties. This has also given the impression that justice is not served in such circumstances, but that the judges may have rather chosen to enable the unjust incarceration of citizens to say that which makes for saying that which makes somebody unhappy or uncomfortable. It is well known that the essence of bail is to ensure that the defendant attends court to answer charges that may have been brought against him. It is therefore worrisome why a court will refuse bail to a person charged with an offence that does not carry more than 3 years imprisonment upon conviction. Judges and magistrates who deny bail to defendants in such circumstances must know that judiciary should not be seen under any circumstance to side with those who wish to silence criticism, dissent, and refuse to be held accountable. I need not remind us that when the government of Jimobodo charged Chief Atomwankwe, a publisher with sedition, for writing a book in 1982 titled How Jimobodo Rules Anambra State, a book that seriously attacked Chief Jimobodo, then governor of old Anambra State, accusing him of corruption and tyranny, the Court of Appeal, in quashing his conviction by the High Court, held that sedition law, that is Section 50 and 51 of the Criminal Code, is inconsistent with Section 36 of 1979 Constitution, now Section 38 of the 1999 Constitution, and therefore void, and the conviction of Atomwankwe was overturned. In the judgment of my Lord Honorable Joseph Olatawara JC as he then was, in quashing that judgment, the citation is applied here. It is my view that the law of sedition, which has derogated from freedom of speech, guaranteed under this Constitution, is inconsistent with 19th Constitution. More so when this cannot lead to public disorders under Section 41 of the 1979 Constitution. We therefore use this opportunity to call on the Chief Judges of the Federal High Court and the High Courts of the States and of the Federal Capital Territory, Abuja, to exercise powers given to them by Section 187 of the ACJA and by the requisite provisions of the ACJL by making regulations for the registration and licensing of corporate bodies or persons to act as bondspersons within the jurisdiction of the court in which they are registered. We must make a commitment to ensure that the bail process is done in such a way that ensure that the defendant appears in court to face trial and same is not abused. We will not fail to use this opportunity to call attention and deprecate the stateful circumstance surrounding the hearing of the appeal filed by a colleague writing against his conviction by a magistrate court in Enugu State. The prolonged delay in determining the appeal gives an impression of a deliberate effort to ensure that his appeal is never heard. It is disturbing that the matter which initially reached judgment stage was truncated on the very day of judgment because the judge refused to deliver judgment and proceeded to recuse himself. Owing to the public outcry and a long delay in assigning the matter to another judge, the matter was adjourned assigned to another judge, who unfortunately, on the 23rd of September 2025, recused himself yet again. It is beginning to look as if there is a concerted effort to ensure that the appeal is ever heard, so that Brian Kingele will serve the full term imposed on him by the court. If this is indeed true, then this is not the face of justice we want to present to the world.